How you guys doing today? It's Anthony Ganji. Welcome to another episode of Tier Talk. Okay, guys, so we're on day 3 of D4vd prelim. We have about 9 areas we want to discuss today. Yesterday was 11, today's 9. There's a lot of activity that happened today, just like the other 2 days. I do want to also mention a correction from yesterday's show, which I also did a short and put it in the comments, but I'm going to give the correction out as well. And then also, I got some clarity on the chainsaws. Some clarity came out today. So that's still causing some confusion through multiple resources. So we're going to hit the chainsaws up again today because that was also discussed today. Mostly was really just forensic evidence. And then towards the end of the day, the medical examiner was brought on to the stand. But then that's when the day ended. So we do have a couple of things to discuss. And I have a quick video to show you on this one, too. And it relates to Steve Fisher, which I think is going to be interesting. Want to have an exchange with Russ on that. At one point, I was following Steve Fisher, and then I just am not a fan of his. I don't think he's in it for the right reasons. And I'm not the only one that thinks that. But before we dive in, let me introduce you to my guest, the same guest I had on yesterday. I'll have on today and hopefully tomorrow when we do day 4. But Russ, mind introducing yourself?
Hey, Anthony. My name is Russ Hamilton. I am a former and retired sergeant from California Department of Corrections. Started my career at San Quentin back in 1989. I'm also a former senior juvenile correctional officer. I currently work for a company, a private company, that does reentry and rehabilitation work at a local county jail where I manage a caseload, and for a county probation department. I am also the author of a book called Killing Complacency, Tactical Awareness for Corrections Professionals, and I'm often found here on Tier Talk.
Yes, and it's good having you, Russ. So we had some activity today on day 3. Let me start off with my correction, guys, so before diving into day 3, I want to clarify and expand 2 points from day 2 coverage. So there were actually 2 LAPD criminalists on the stand, not just one. For some reason, I thought there was one. I didn't have a name during the second testimony, and I automatically attribute that to having just the one criminalist, but actually there was 2. So earlier I described the criminalist walking through the garage and the Tesla evidence. In fact, day 2 featured 2 separate LAPD criminalists. We had Lauren Wallace. She's a criminalist with the LAPD Forensic Science Division, testified about the garage, the interlocking black rubber gym mats with slits, the brick floor underneath, the trash bag full of wipes, the blue kiddie pool, tarps, the rowing machine, and the Tesla charger, all sprayed with Blue Star and flagged as possible blood. She explained that Blue Star reacts with iron and hemoglobin, making latent stains glow blue, and emphasized that she could only say possibly blood at the scene. Final confirmation has to come from DNA lab testing. And guys, if you haven't, please watch day 2. I do break down more specifically of what she discussed. And then you got Chelsea Murillo. That's another LAPD criminalist focused on the Tesla. She testified about smaller but similar possible blood stains inside the vehicle, including in the rear seating area, and documented the 11 air fresheners scattered throughout the front, center console, rear seats, and door pockets. Her testimony, combined with photos, showed maggots, dead flies, and an odor consistent with a decomposing body, supporting prosecutors' claim that Celeste's remains were kept in the car for weeks or months. She also confirmed under cross-examination that her blood test result was only presumptive. It did not prove blood was definitively present. And when, if you watch my day 2, when I am talking specifically about the Tesla, I wrongly attributed that to, I think it was Lauren Wallace. It should have been Chelsea Murillo. And I knew it was 2 guys. I had it in my reporting as 2, but somewhere along the line when I transferred it over, I forgot to put the name in. So the forensic story on day 2 came from 2 voices, Wallace on the garage and Murillo on the Tesla, so it's not just one. And number 2, and I'm upset with this because I had this in a whole separate note and I forgot to bring this set of notes over. So I unfortunately forgot to cover this in yesterday's episode. But real quick, there was a California Highway Patrol officer also testified about finding Celeste's passport. Day 2 included testimony from a California Highway Patrol officer about Celeste's passport card. He told the court that a Caltrans worker found the passport in a brushy dirt area off State Route 154 near Lake Cachuma in Santa Barbara County, roughly 95 miles from Burke's Hollywood home in January 2026. The worker turned it over, and California Highway Patrol logged it and passed it on to investigators. That's extremely important because it's part of tracking David's whereabouts, and there's basically a lot of curiosity in the discarding of that passport. So, Rush, just a question here, because these are two areas. Well, at least the California Highway Patrol was an area we should have touched on yesterday. Now that you know two different criminalists split the garage and Tesla testimony, and that California Highway Patrol officer specifically tied Celeste's passport to a remote Santa Barbara County roadside, does that level of separate corroborating documentation make the deliberate disposal theory feel stronger to you? I mean, that really doesn't. That's really
it doesn't. It doesn't add anything. It doesn't subtract anything either.
Yeah, and I think, as I said yesterday, we covered it so much in detail. I think we can move forward without having to explore this part. All right, so let's go to the first part of day 3. So day 3 opens with some courtroom drama, and this is even before the testimony even starts. So I'm going to do this, give the question to Russ, and then I think I want to show you guys a video, a very quick video, just a section of something. The video will be coming from, what's the channel? Surviving the Survivor. But let me... So let's give you a little breakdown. So day 3 began not with evidence, but with the judge addressing serious concerns about courtroom conduct. She first addressed an email sent to the court's media office at 3:51 p.m. the day before regarding a shared Google Docs file containing a live transmission from inside the courtroom, reportedly being shared with a content creator in another state providing live coverage of the previous day's proceedings. That is a direct violation of the court's rules against live tweeting, texting, or otherwise transmitting real-time details from inside the room. Deputy DA Beth Silverman then raised additional concerns. She told the judge that a woman seated in the back row had approached her multiple times before the hearing and made comments Silverman described as negative and directed at her. A lot of people believe this is either to be a family member or supporter of Burke's. Silverman also argued that private investigator Steve Fisher should not be in the courtroom because he was a grand jury witness in the case and could be called as a trial witness later. Potential witnesses aside from victims like Celeste's family are barred from preliminary hearings. I'm going to show you the exchange because I have Steve Fisher. He was interviewed today on Surviving the Survivor, and we'll give you his perspective on it. Silverman further criticized Fisher for speaking with Celeste's family's attorney, Patrick Steinfeld, in the courthouse lobby, calling it inappropriate given Fisher's potential witness status and his professional experience, which she argued should have made him know better. She said she believed Fisher would post something publicly about the case because he posts something every day. The judge ultimately ordered Fisher removed from the courtroom. Following that ruling, Silverman and Steinfeld, that's the Celeste Rivas' family attorney, reportedly had a tense exchange at the attorney's table with witnesses in the courtroom saying they heard Silverman tell Steinfeld, "Push me, you'll see how far that goes, and I'll pull your badge." TMZ separately confirmed the PI was removed after Silverman flagged his grand jury witness status, and that both Fisher and Steinfeld told the judge they hadn't realized their conversation violated any rules. Fisher said he didn't even know who Steinfeld was, and Steinfeld said he didn't realize Fisher could eventually be a witness. Silverman warned Steinfeld she would pull the courtroom access badge if it happened again. You guys, Fisher, you just can't trust this guy, in my opinion. Let me show you this video real quick, Russ, because this is going to show you what happened today. He was interviewed right after this, of course. You know him. He's got to put himself in the center of every case. I just don't think he's on the family of Celeste's side, because he was bad mouthing them as well. All right, hold on.
Yeah, so it's been kind of wild because they have press people that have press credentials that were pre-selected, and so they've got seats and they're assigned, and then but then they have 10 spots for the public and 10 public standby seats. Although the standbys have gotten in every day, so call it 20 seats. But the thing is that the press is also entering this lottery because they want extra seats. So every day, like Brian Enton and his group are there putting their tickets in the little tumbler. And in fact, he's a very lucky guy. He's gotten drawn each day he's been there.
Yeah, I said that yesterday, Russ. Didn't I say that yesterday, or maybe on my own when I did? It's crazy how he's always finding himself in there. You know, it's. I do agree with Steve on that. That's unique. Okay, hold on.
So
the fix is in. The fix is in.
Yesterday they got 4 of the 10 spots at the news station. So, but it, so everybody huddles around down in the lobby of the criminal center, and people coming in that don't know about the history and other stuff are like, "Hey, can we play? What's going on?" Because it's just ridiculous, to be honest with you. And then if you get drawn, you go up to the 9th floor, and you have to go through secondary screening, and you have to deal with the elevators getting up there. So people are actually getting up there, and the court's already started. And then you get seated, and it's a medium-sized courtroom, and it's tight scene, but they're running a very, very tight ship, and the lady who's running all the seating and doing drawing the tickets and stuff is doing a phenomenal job. She really is. Very well done for what it's kind of a really goofy system. I'm sure she didn't come up with. And it's silly because they have armed deputies calling out numbers 4722, and people are cheering when they get. It's like, this is a murder trial. Somebody, a girl lost her life, but people are doing it. And this is stuff like yesterday, a big group of people came in, and they were like David supporters, and they got a couple seats, which is fine. I mean, they're allowed to, but it's kind of a wild scene. You wouldn't think it was for something as serious as it is, but once you get up on the 9th floor, it's very serious in the hallways and stuff like that, and they're not giving any leeway. The bailiffs and stuff like that. They have a bunch of bailiffs in that courtroom right now, each day.
Yeah. So I know Celeste Rivas Hernandez's parents were there. I don't know if you saw them. Do you know if David Anthony Burke's family are there? Are his parents there?
I haven't seen anybody from his family, but I don't know what they all look like either. But to me, it did not look like Celeste's mother and father were there, and the family attorney that's representing in wrongful death, potential wrongful death. But I haven't seen anybody from his side. He doesn't really look at the gallery when he comes in. They bring him in, they shackle him to death. They've been taking it. The judge has allowed them to take his handcuffs off during the proceedings. He wanted to be unshackled. She wouldn't allow that. She said he needed to be shackled to the desk. But so he is, and he just stares forward at the monitor. And he doesn't. A lot of people turn away, like when the medical examiner photos, the crime scene photos of her body, her remains are up there, and he's just stared forward at the monitor. Where a lot of people have had to turn away. Not him.
You're invited to join Phoenix Energy's.
Hold on, Russ, because I gotta find the part where it's right around here. Hold on one second.
And that's odd that because these are really, really gruesome pictures. I know.
Time to order a pink chainsaw. I mean, there's like production value.
They just give him the sentiment.
And I think he knows he's done. I really do.
Bro, the discussions. In fact, he's giving them a lot of information.
Sick. So going.
I had it ready.
Don't know.
Here, hold on.
Would we see potential?
All right, guys, I found it. Hold on. Sorry about that.
Pointing to Steve Fisher. Steve, what happened? When did this happen? Yesterday?
No, this was this morning. Yeah, so so I have to give a little bit of backstory, otherwise it will make sense. But so
please,
this crime was discovered back in September of 2025, and I was hired by the homeowner where David was living and the Tesla was parking, and then possibly that this crime happened at. And there was little to no movement on this case for a very long time. You know, we found evidence at the house, like we found an SD card from a camera that, you know, he had left behind. We recovered all the photos, a burn cage, a chainsaw that had not been taken during a search warrant. The house directly across the street had a 4 terabyte hard drive surveillance system that LAPD never came back and retrieved. They said they were going to, and the homeowners were like, it's going to overwrite like tomorrow. So we took it, and you know, so we got vocal, but we were like they wouldn't talk to us privately. They were just like, oh, you know, leave a message. And so we got vocal. The homeowner was like, you know, we need to change the mission from, you know, finding out like why this guy was in my house, because he didn't lease the house to David. He leased it to Josh Marshall. And he's like, I have no idea who this David is. Now all of a sudden my house is wrapped up in this murder. So he's like, but we need to change the mission from finding out like who he is to like making sure that nothing falls through cracks, like, and this girl like gets justice, because it doesn't seem like a whole hell of a lot was happening. And so we pressed, you know, and we put stuff out there as we felt we needed to for it to get traction, and it finally did, you know, and Beth Silverman, the DA, did not like the fact that we disclosed that there was evidence left behind that we thought was important, right? And she's like, you know, people don't need to know that, whatever. So she didn't like the fact that I was doing interviews. So all of a sudden, and I'm just disclosing this now because she brought it up in court today. So she's the one who let that cat out of the bag.
Yeah.
But
well, I think she said that you were a witness, the way I read it. That you were.
That's let the cat out of the bag about that. That's why I haven't talked about the grand jury, but now she put it out on record. So back in November, I had 6 in the morning. I had 2 DA detectives show up at my door and subpoena me as a grand jury witness, and I appeared. And but what was strange about that was they immediately said you have to call Beth Silverman right now. And I did, and she told me, you can, now that you've been subpoenaed, you can never, ever talk about this case again to anybody, including your own client. You can never bring it up again or you're going to jail. And I was like, okay. And I didn't, you know, I haven't dealt with grand juries and stuff a lot, but I started researching the law, you know, because it was only 6:30 in the morning, so I couldn't call attorneys that I know. And I saw, well, as a witness, you actually, the secrecy is for the grand jurors. A witness can talk about their own testimony. They can't talk about anything they learned from a grand jury. But I was like, and so I clarified with her. I'm like, wait, you know, I have a client. Like, so you can't talk about the case. Period. You'll go to jail. And but I found out that was wrong. And I testified, and she's the one who brought it up today. And then what she did is she subpoenaed me again and say, well, you're still under subpoena now. So for 2 months from now. So can't talk about the case. And I told her, and I appeared a second time, and then the same thing happened again on the third time. And I told her, I said, I'm not going to, I said, I am talking about the case again. And I know that what you're telling me is inaccurate. And she handed me, which I put on Twitter, a handwritten note saying that I had to appear in court on Tuesday for a order to show cause hearing, for you know, talking for talking, and I'm like, can I get a case number? She's like, there's not a case number, just show up. I'm like, it's a handwritten note. This is not this. And she's like, you need to be there, or there'll be a warrant issued. And so I you know, and she said, this is for contempt. And I'm like, well, can I see, like, I need to know what I'm defending myself against on Tuesday. It's Friday. I'm like, you're telling me I got to be here Tuesday. And so what I did, I was supposed to leave town, and I did leave town, but I FedExed a letter to the court, because she gave me it was in Division 105 or whatever. And I said, I'm not going to show up for these reasons. You know, I have not been, I don't have a case number. It's a handwritten note. And the other thing is that I put it down on Twitter, and I said, the only way I can see I can protect myself from this possibly being thrown in jail secretly is to let the press know about it, right? And so Tuesday came, and they did show up, and there was apparently, like I wasn't on the docket, but there was like a courtroom that they were expecting me to possibly show up at. So, and after that, I never heard. So anyway, I have to tell that story because when I and since then I've showed up at the arraignment and other stuff like that, and she see me in the room. I've gotten some dirty looks or whatever. Yesterday, I did not draw a ticket, but I was in the hallway outside the courtroom, and I was talking to someone, and this gentleman came up to me in a suit, and he said, "Steve, I want to introduce myself. I'm Patrick Steinfeld. I'm the attorney for Celeste Rivas' family." And I was like, oh, "Okay." So we stepped in the middle of the hallway, and he said, "I just want to thank you for what you've done. You kept the story alive when people wouldn't, even though you've taken some shots at the family, at the mom and dad for, he's like, I get it." And he's like, "But they want to thank you too." And I was like, I asked how they were doing, and because the case really has touched me. And he told me, and then all of a sudden I see Beth Silverman storming down the hallway, and she came and physically grabbed him, yanked him away from me, and said, "You are not allowed to talk to him. You are not allowed to." Start yelling at him. So I was like, and she did it in front of all these reporters. I was like, what in the world is going on? So then today I do draw a ticket to get in, and I'm seated, and they go on the record to start the case. And there's another matter before me of somebody that was live streaming or live tweeting from whatever. And then the judge says, "Are there any other matters before we call the first witness?" And Beth said, "Yes. There's a private investigator here that I want thrown out. He was a witness to the grand jury, and he failed to appear. And he failed to appear, and there's a warrant for his arrest." Both those things are completely untrue. And she goes, "And he illegally approached the witnesses, Celeste Rivas's family, out in the hallway when he knew he's not allowed to talk to any witnesses." And so the judge kind of stopped her and she said, "Listen, I don't, any matters of the grand jury, just stop, don't stop talking about it." She's like, "Mr. Fisher, if you were potentially going to be called as a witness, you were on the grand jury, she can use the exclusionary rule. I'm going to have to ask you to leave." She was very, very professional and kind about it. And I said, "Your Honor, I completely understand." And I started to walk away, and then Beth kept talking. The bailiff's like, "Go back to the front of the courtroom." I went back, and she was saying something, and then I said, "Can I put something?" I said, "Your Honor, can I put something on the record?" And she's like, "If it has anything to do with the grand jury, please don't." I'm like, "No, it doesn't." I said, "But I was just accused of approaching witnesses illegally, and so I said, I just want to make it clear, because Patrick Steinfeld was in the courtroom. I said, he came up to me, and then she turned around I was looking right at her. She turned around in her chair and looked at him and said, "What the fuck?" And then Steinfeld stood up and said, "Your Honor, I just want to clarify. I did approach Mr. Fisher, and I didn't know he was a member of the grand jury, or was this going to be a problem?" And then so I bowed out and I left. And then I guess after I left, she said, "You keep pushing me, I'm going to yank your badge, see what happens," to Seinfeld. And, so I don't know. It was very bizarre. She clearly told me that I would never be called as a witness. She's like, it was used as a method to jam me up. So she thought I wouldn't know my rights and I wouldn't talk to the press. And
all right, so I do want to show that, because that's been going all over social media right now, the news. I'll be honest with me and Russ. We've talked about SF before. We've done a lot of videos on him. I'm at first, when I started doing this true crime stuff, I'll be honest with you, I like the fact that he was getting information when the world was shut down on Celeste Rivas for a little bit. But then what hit me was, wait a second. I work in law enforcement. This stuff really maybe shouldn't be released. Who the hell are we to demand that? Social media, whatever. And then he's going out there, in my mind, messing with the integrity of the investigation, kind of just doing his own thing while the investigation's still active. Plus, he's working for the homeowner who probably was having contact with Joshua Marshall. So I just felt, and I think there was some concerns going online that he was in communication with the other side. And what I didn't like was at that point, I kind of just didn't like the fact that he was releasing stuff and definitely passing judgment on the job being done. And I think it was quiet at that time because they were preparing their case. And by the way, even though it's not perfect as we go through these things, obviously the LAPD, robbery homicide division, all of them, they put together something. Beth Silverman put together. So, I mean, they got some serious 40 terabytes worth. So you can't say they weren't doing anything. I mean, there are some concerns with the collection of evidence. I guess the burner, the chainsaws, but with that said, there were other avenues that I feel that they have explored very successfully. But again, I don't I think that guy's out to exploit this case. And also it's unique because me, Russ, everybody that has been on the show discussing Celeste Rivas with me, we've never attacked the family. He has. And what gets me upset is for the lawyer to tell him, oh, it's great what you've done. I know you've been, I know you've kind of made some hits on the family, but they understand. Have you watched what he says? Basically, he would say that the mother and father were exploiting their kid. What family would accept that if they weren't doing that? Russ, my first question here is, with Silverman threatening to pull the badge of Celeste's own family's attorney and having a PI physically removed from the room, do you think she's being appropriately protective of the case's integrity, or does this level of aggressive courtroom policing feels like overreach towards people who are technically on the same side as the victim's family, which I don't see. I think Beth Silverman is making the effort to protect the case. What is your thoughts on this interaction? You're muted, Russ.
Yeah, this is his story and his spin, you know. So there's he's telling the way he sees it, and I'm just, if he'll run a family through the mud like that, I got nothing for that guy. What he says about the about the judge or about the prosecutor, anything, I just, man, it's just water off a duck's back. I got nothing for him or about him.
Yeah, he makes it look like that, as always, in everything he covers, that he's the center, he's the hero. LAPD and the robbery homicide, they weren't doing their job. The district attorney's not doing, yet they are. All right, so again, if you guys want to know our thoughts on SF, I got tons of videos. Just put Tier Talk SF. And Russ, real quick, one note before we go to the next part of the day is, it's kind of funny how it's supposed to be a lottery, which I'm sure there's a lot of people trying to get a ticket, and yet you find the same people in there more than once. What's the likelihood of lightning hitting them twice,
Yeah, well, I think it's hard to say because you don't know how many won the lottery out of how many were entered. So,
let's see if they get in again tomorrow, because that's 3 days in a row now. I mean, at one point, that's it's pretty damn lucky. So section 2, there's a cross-examination of Wallace. Then we continue talking about the chainsaws. Maybe I'll get some clarity here. And then it's fake blood and what wasn't tested. So testimony resumed with LAPD criminalist Lauren Wallace back on the stand. This time under continued cross-examination by defense attorney Blair Burke. Burke focused heavily on evidence investigators chose not to collect or test. Wallace confirmed that 2 chainsaws, an orange and black one, and a pink one, were recovered from the Hollywood Hills home and both tested negative for blood. She said the handles did not appear to have been used, so investigators determined not to collect swabs from them and confirmed that no touch DNA was collected or tested on either chainsaw. Only the blades were swabbed, and those came back negative for blood. Burke pointedly noted for the record that there was no proof of touch DNA on the chainsaw. Now, Burke then asked about a third electric handheld saw found in a storage closet inside the rental home. Wallace testified that Saw also tested negative for blood and was determined not to have forensic value, so it was not collected either. Burke also asked about containers of fake blood and trays found in Burke's garage. Wallace said those items were documented and photographed, but not collected because they also tested negative. So real quick, they mentioned the third chainsaw again. This time, it was recovered. The chainsaw thing is real confusing. I'm not going to dive deep in it again because even now, when I was doing my research on it, it's still all over the place. And sidebar with what's his face, Weber also said it's getting to be a bit confusing with the chainsaws. On redirect, so Silverman comes back. Silverman emphasized that investigators do not collect every item found at a scene. They focus on items with potential forensic value and asked Wallace directly whether the team was there to collect touch DNA. Wallace said no, that wasn't the purpose. They were screening specifically for blood evidence, and touch DNA collection wasn't part of that scope. So Russ, first question. Does the fact that none of the 3 saws or the fake blood containers were tested for touch DNA feel like a meaningful gap in the investigation to you, or do you think the presumptive blood test already found elsewhere in the garage makes this a minor issue? We're kind of revisiting what we touched on yesterday because it seems to be a very strong topic even into today's discussion right at the top of the day.
So, people see this as gaps, but it's not. Sometimes that evidence is collected so that the defense can test it later. But there's some pretty meaningful constraints that are put on crime scenes by the lab, by the workflow, and things like that. They can't just go in there. They don't just have, an unlimited number of swabs that they can hand over. That's kind of, restricted, per crime scene. It's usually like 5 to 15. And so when they don't have, trace evidence on something on a chainsaw, and so they just do like one swab and they're not looking for anything else but some blood evidence. Yeah, some of that is going to get, overlooked and not tested, but that's part of the process. Otherwise, how many thousands of swabs would you do? And you're always, no matter how many you do, the defense is going to say, oh, well, it wasn't enough, but it is. And then, part of the screen out process has to do with the way they look at whether there was trace evidence on there to begin with. So if they had something that was, being highlighted by the reagent a lot, then yes, they went and tested those. But they can't just decide they're going to swab thousands of things. They're limited by that, and they have a complex workflow where there's multiple scenes, as there was in this case, because we have the Tesla, for instance. Then they get to submit a few more, but I think the amount that they're generally allowed for something like that on a car is like 3 or 4. So it's not that many. And so what you have is the defense trying to pretend that, oh, there's all these gaps and stuff, when that's just the workflow, that's just the lab constraints, that's just what the limitations are on that type of crime scene. So I think it's way overblown.
And Russ, if they did send it out for further testing, and let's say somewhere along the line they found some touch DNA from David, then they would turn around and say, but there was no blood on the chainsaw.
Well, that's what they call, evidence of presence in your own home isn't going to be evidence of anything.
Right.
It's not. When it's not dispositive. That's just simply probably not even going to be allowed into the record.
No, I'm saying, but right. And I think they would have had to angle both ways, because if I know they're trying to question the due process, cause doubt, cause confusion. And I know that's what they do, but it's funny. And let's say they did decide to test it, even though it didn't have any blood DNA on it. But let's say it did come back with, like you just mentioned, touch DNA from David along with 20 million other people. they would have also complained, well, 20 other million people are on it, but their biggest argument would have been, but there's no blood on it. So I think I understand, like, okay, if there's no blood on the chainsaw and there's no traces of blood on the chainsaw, I mean, yeah, we could touch it for, we could test it again for whatever it is, I guess the touch DNA, whatever they want to do. But the problem is there's no blood on the chainsaw. It has no value because, okay, so anybody could have touched the chainsaw, but where's the blood on the chainsaw? It's like, in my mind, I could be wrong, Russ, because you seem to know this a little bit better than I do, but they wouldn't be able to win anyway, because if I was to test that and it comes back with David's, let's say, touch DNA, whatever it is, then you would go back and say, but there was no blood on it.
Yeah, and that's what it is. That's why they're, to some degree or another, limited by, like I said, by the workflow, by, what the lab is willing to accept. The fact that they went ahead and they swabbed those two saws, even without evidence of blood on them. They did just the teeth, I believe, to look and see if there was anything, trace there, that not the luminol, but the reagent, the blue star on there. I mean, they went the extra mile, and they can't just start burning up the number of swabs that they've got to do. They have to save them for the things that are really truly meaningful. And so they go through and they decide, hey, where are we most likely to find some good evidence? And that's what they do. And so it's just with regards to the defense, too bad, and those things, and a lot of those things are saved so that they can test them if they want later. But truthfully, this reeks of desperation to me. This is, and it's not that I don't expect them to challenge everything, because they should, but if this is the best shot that they've got, then this is a slam dunk.
All right, let's get to the next part. So the trace evidence bombshell, blue pool fragments match wounds like puzzle pieces. So the most dramatic testimony of day 3 came from Lisa Lehendro, also reported as Leah Lehendro in some transcripts, an LAPD criminalist from the department's trace analysis unit with 26 years of experience, including 22 years specializing in trace evidence, the microscopic examination of hairs, fibers, residue, and other transferable materials. Lehendro testimony centered on the blue inflatable kiddie pool recovered from Burke's garage and on Celeste's clothing. She testified that she examined and recovered hair fibers, plant material, and black or blue foam-like flakes that had separated from the pool's surface using a stereo microscope. She also said she observed possible footwear impressions on the pool and attempted to lift them using an electrostatic dust print lifter, but the impressions were too faint to successfully recover. She identified 4 damaged sections of the pool, labeled A through D, describing the damage as a mix of straight linear cuts and irregular scalloped cuts, some cutting completely through the material. She then compared blue plastic fragments submitted by the medical examiner's office, which had been recovered during Celeste's autopsy, against the damaged sections of the pool under a stereo microscope. Photos shown in court appeared to demonstrate several of these fragments physically fitting into the missing cutout portions of the pool, described by witnesses and commentators as fitting together like puzzle pieces. Additional images showed roughly a dozen smaller blue fragments sharing characteristics consistent with the pool's material. And by the way, guys, Celeste's family is watching this. Mom and dad are watching all this again. Looking at the pictures. It's just, so Lehendro testified that the fragments could have originated from the inflatable pool, but stopped short of confirming an exact match because portions of some fragments were missing. She confirmed the fragments arrived from the medical examiner's office in sealed evidence bags maintaining chain of custody. This directly updates earlier reporting. Initial court filings suggested the blue plastic embedded in Celeste's remains might have come from a blue chainsaw casings. Lehendro testimony instead ties those fragments to the inflatable pool itself being damaged during the dismemberment, not a chainsaw shell. And again, that was part of the confusion. Social media commentary on this testimony was blunt, with one widely shared clip describing the fragments as a perfect match like two puzzle pieces coming together and suggesting there's no clear defense against this specific piece of evidence. Though it's worth noting, Alejandro's own courtroom testimony was more measured, describing the fragments as consistent with, but not confirmed as an exact match to the pool. The question here, Russ, was given that Alejandro herself testified she couldn't confirm an exact match due to missing fragment portions. Do you think the puzzle piece visual is as damning as online commentary suggests, or is there more room for reasonable doubt here than the viral clip implies? Because there was a viral clip that was going around talking about, she said the four pieces of the pool, the four main pieces fit like a puzzle, but then there were other parts of the pieces of the pool that didn't. What's your thoughts on that, Russ?
Well, she said that she did a visual match, but not exhaustive. And that leads me to believe that she might have more work to do. And so, some of that, may come to light later. There might be more time for, more microscopic examination of some of those pieces and how they may fit or may not fit. So it just, they may have not found the one smoking gun, for lack of a better term. But, there's stuff that was, embedded in Celeste's body. There's stuff that was left at the crime scene. There's stuff, that they may have recovered doing something else. And so she's saying that it was not exhaustive, but she did narrow it down to the point where she did say that there's a visual confirmation that it's the same type of material. And so that's pretty damning.
Yeah, and by the way, since we've been covering true crime, do you ever really get someone that says it's definitive? It's more about probability, correct? Even though the defense is going to want to push something definitive.
There can be, definitive, there can be, really definitive types of evidence. In this case, it's circumstantial, but once again, I'll get back to what I say all the time. Circumstantial evidence is the best evidence, and it just keeps piling up. There's nothing in this that helps David at all. I think that, what you're going to see is you're going to see this evidence continue to mount, and they don't need an eyewitness. They don't need an absolute definitive match from this material. It's going to be the totality of the weight on that scale that's going to matter in the end.
Yeah, and guys, I did a video earlier today that discussed kind of what I feel happened when Celeste's life was taken. And I kept on getting comments. I think Mona just posted up right now that people said, well, why did he leave the body in the car? And people want to come with all these elaborate things. I just think he didn't know what to do with the body. It's that simple. He was a desperate man.
I came back, I know on a couple of the videos talking about is once you let it get to a certain condition, then what is it that you can do about it? And there's not a lot of good answers, and you can't drive the car anywhere because you're going to retch and be exposed to, some biological materials that, can make you very ill. And then on top of everything else, how does he reach out to anyone to have him help him with that? No one's going to want to get involved in that. It's, talk about a horrible job. And he just probably, didn't have any idea that, the condition of a body was going to be that difficult to deal with. So he flubbed up, and we've already seen he's a very immature individual. He's not very, world wise, let's put it that way. And so, what is it that he could have done? He could have torched it, but he would have needed to be somewhere where it wasn't going to be found for a long, long time. And so there was no way for him to move the car. And if there's no way for him to move the car, then, he's stuck with it. And so at some point, it was just, sitting there waiting to be discovered for however long.
I think ultimately he was also looking maybe to hope that he could get rid of the car too, because this body was liquefied. And as you can tell from the testing that's been done from the criminalist, the DNA was all over this car. So I think ultimately it no longer became about just getting rid of her body. It became about getting rid of the body and the vessel, the car. I think that became a concern too. I think he was looking maybe at one point, I could be wrong, is maybe eventually to get rid of both at the same time. Would that make sense to you, Russ?
Yeah, but how do you do that? You can't call a tow truck driver, you know. So it just became what it was, an impossible situation.
All right, so now we get to cell tower data, places Burke's phone and Tesla in Santa Barbara 3 times. So LAPD Detective William Roker of the Cellular Analysis Survey Team, working alongside the FBI, testified about location data mapping, Burke's movements after the alleged killing. Using historical call and cell tower records, Roker analyzed 2 mobile devices connected to Burke, including an international line tied directly to the Tesla, and testified that both devices moved together from Burke's Hollywood Hills home to the Highway 154 site in Santa Barbara County, where Celeste's passport was later found on 3 separate occasions. And that's kind of the connection with the passport. It is extremely important. April 23rd to the 24th. So this is the day April 23rd is when they believe he took her life. And then right after he took her life, I don't think he had Celeste's body with him in the vehicle. I think that's when he drove to try to figure out what he could do with her to Santa Barbara. So from April 23rd into the early morning hours of April 24th, 2025, hours after investigators believe Celeste was killed, both devices traveled to Santa Barbara at 12:04 a.m. On April 24th, an outgoing call was placed from Burke's phone to Celeste's own number while he was in the area, despite prosecutors alleging she was already dead. The Tesla returned to Los Angeles by 7:07 a.m. I think this is where Burke tried to make it look like she never came to the house. What's going on? Where are you? And at that point, he had probably already killed her. But the phone call at that point was, I didn't see her that night. It was preparing for an alibi. May 8th to May 9, 2025, cell tower data again placed both devices near the highway site overnight. And then May 31st, 2025, both devices traveled back to the location with records showing the Tesla stopped at a charging station near the Passport Discovery site before returning home. The defense objected repeatedly during this testimony, arguing that Roker could only say the phone and car traveled together, not that Burke himself was driving or present, since cell tower and vehicle telemetry data can't place a specific person's hands on the wheel. Prosecutors' theory is that the calls to Celeste's dead phone were an attempt to create a false appearance that she was still alive, and that the repeated trips to the same remote stretch of highway represent Burke returning to a body disposal or evidence disposal site. Russ, question here is, with cell tower and Tesla data placing the same devices at the same remote highway site 3 separate times over 5 weeks, including a call to Celeste's own phone after she was allegedly already dead, do you find it wasn't necessarily him driving defense argument persuasive, or does the pattern of repeated trips feel too specific to explain away?
Yeah, I don't know. I want to say it's too specific to explain away, because it certainly could be explained, but all we're seeing at this point is an attempt to make that, dispositive. Well, it might not have been him. Again, clutching at straws, reeks of desperation. And the thing that they can't do is they can't call him to the stand to refute that. He can't say, "Oh yeah, I lent my car at that time to Lenny or whoever," And so it is what it is. I think it looks bad. I don't think that you can assign 100% weight to it, because they're right by the fact that he did not. He was not identified in the car. But then again, if they're going to go that route, I highly doubt that her cell phone was the only number he called. And if he called other people at all during that, and they say, "Yeah, I talked to him at that time," then that's a rabbit hole that but they're willing to go down right now, but they may not be willing to do that in court.
But you could see, obviously, I mean, and we've seen this in other cases before where you kind of track the data of the phone, and then eventually you still have to prove that the person was holding the phone. And like Russ said, what other calls were made at that time? That's always a way to look at it. Or did he ever report his phone was stolen? I've seen that pop up. Did he ever say that his phone was stolen? So what reason would we have to believe that he didn't have his phone? So I think the big thing is even though at a preliminary hearing,
wasn't that the same phone that they recovered and he had some troubling photos on it?
Yeah, I think that's you know what? That's a good question. Let me find out. Hold on. And then also, I wanted to mention something. Let me see if that is the same phone. That's a great question. And also, I want to mention something. In here, obviously, the pre-hearing, you may be able to have a back and forth and through hearsay, get some probable cause. But eventually, when it goes to the next level, if it does go to trial, pushing ownership of the phone, and maybe what Russ just said, look at the other calls he made at that time or could have been made, and maybe me just adding the fact that he ever report the phone missing. I mean, would that hold enough weight later on so we can hold him to that vehicle during those times? As long as you can explain, first off, it's not even just about, tracking him in that vehicle. It's why was he in that vehicle? So motive would matter too.
Yeah, but what you've also got there though is it said that he used a recharging station. So, whose credit card is on that recharging station? There's a lot of different things that that's
a good point too. So this is for the phone. They're talking about the international phone line that was tied to the Burke's Tesla, not the car's built-in information system itself. In court reporting, that line was treated as one of the two devices which location data could be tracked alongside the Tesla's movement. What that means is the Tesla was associated with a phone number account line. That line appeared to move with the car and the cell site records, and Roker used that to show the phone and car were in the same place in the same time. So, yeah, but we're asking about what about the phone he had, right? That's what you're talking about, right?
Yeah, they recovered a phone from him that, like I say, it had some troubling photos on it. If my recollection is correct.
Okay, so let me ask that. Was this the phone with the CSAM? I don't know if that was. I wonder if that was. I don't know if that was brought up. Because that, you know what, you made a good point. Because I know what you're trying to say, Russ. I think you're all right. So I think what you're trying to say is you're going to try to find different ways to connect them to the phone. So if you can connect them through the child sex, that's great. But also, if you can connect them through here, that can later connect them to that phone again. So it says here. Yes, reporting indicates the child sexual abuse material allegation was tied to Burke's cell phone and iCloud account. We know not the Tesla link line. Prosecutors said a significant amount of child pornography was found on a cell phone belonging to David Anthony Burke as part of search warrants on his phone and iCloud account. A separate report says the prosecution would not specify whether that material involved. Okay, so let's say it was, because there's really not enough here to say if it was or wasn't. But so now, I think this is interesting because now you have to get ownership, right? So if you can establish ownership this way, then will that help out later on? Or are they still going to say, well, how do we know he put the child sexual abuse material in the phone? Well, it's him in the video. It's him in the pictures. So I think that, like we're saying, this is a good point to present kind of an avenue as to where they're going. And I think there's enough evidence to be able to showcase specifically that it was him. I mean, ain't there videos being taken in Teslas too?
Yeah, but they might not have been stored, or he might have even been smart enough, although this is one dumb guy. He might have, turned off some of those features or something.
So, Russ, if I can ask you a question, when we move, if this ever goes to a real trial, and let's say we're just in isolation, we're focusing on here and trying to connect him to the phone as it moves to Santa Barbara. So him in the car being connected. what would be, I mean, you would have maybe video of him leaving the house, going into the car. I mean, they got video of him returning on July 29th at 2 p.m., that final video. So maybe they just have video of him leaving the house, going in the car.
Yeah, not all of the discovery is done. And so, we're looking at this, we're on the outside looking in at the fishbowl, and we can't necessarily see all of the fish, just some of them.
Right. So you definitely think, I don't think it's going to be that hard to put him in that vehicle, right?
No, I'm sure that they do. I'm sure that they have a list of things lined up like this, that at some point, they're going to dump on the defense. And like I say, right now they've already shown some of their hand, and I think the defense right now has to be going is just thinking, how much more do they have? And so, I guess we're gonna see, but maybe not. Maybe he will take a deal.
Right, but it is important that they get him with the ownership of the phone, because the problem is, I mean, I don't know. Again, I don't know if he was dumb enough to put himself in the pictures with Celeste. I'm thinking that they were also able to identify him as the owner of the phone, not even just through the digital forensics, but when I'm talking about like iClouds, whatever, I'm talking about maybe he's in the pictures. So it's like,
but he probably, on at least one of the phones, I believe they said that and I'm not sure which one it is now, they had connected him through the credit cards and other things that were on the phone.
Oh, payment? So, you mean payment to the phone bills?
No. I mean that he had.
Oh, the store. I got you. Like the credit card.
Yeah. So you got your Google Pay wallet and stuff on there,
Venmo,
and so
and all that stuff.
Yeah.
That's interesting. I forgot, man. World's changing right now. I mean,
you can't go anywhere without leaving a trail now.
All right. So the medical examiner takes the stand eventually, talks about the identification through dental records. So medical examiner testified that Celeste's remains were identified through dental records, given the advanced state of decomposition. The examiner stated she weighed 71 pounds and was listed as 5'2" tall at the time of the examination. Stark clinical numbers that underscores how young and small she was. The cause of death was previously ruled a homicide from multiple penetrating injuries with unspecified object, and this testimony reinforced how severely decomposed her body was by the time it was found, nearly 5 months after her alleged death in April of 2025. Russ, hearing her weight and height stated so plainly in a medical examiner's clinical testimony, by the way, the family is watching this right now. They're in the courtroom. 71 pounds, 5'2". Both she had braces, I believe, as well. Does that kind of stark factual detail hit you harder than the more graphic forensic descriptions we've covered so far? I mean, she was 14 when he took her life. Sorry about that. 14 when he took her life. She's 5'2", 71 pounds. That's extremely underweight.
Well, you got to remember though is that even though there was a lot of liquefaction of the body, there was also a certain amount of desiccation too. She lost most of the fluids at that point, so that just kind of like scores with what I would expect a body in that condition over that period of time. I think that the thing that really hits me is really more about her age and the fact that he robbed her from 60 or 70 more years of life, and so that's kind of the thing that really hits me harder than just thinking about the condition of the body, because bodies do that.
Yeah, and what gets me on this too is knowing that the family is viewing this as discovering.
I could not do what they're doing,
right.
But I do understand it, because I think that they feel like they owe their daughter justice in a way that they're willing to withstand what killed her, and get something out of that.
Well, they want answers. you know. And by the way, the scary thing is they're discovering it the same time we are, you know. But when me and Russ been covering true crime, one of the things I realized in my coverage is that I used to think the victims, the families, they were kind of in the loop throughout the process. And then through cases that we've covered, Kohlberger case a little bit, this case here, the people that are mostly affected, they find out at this level at this time, you know. So they're going through the same, I mean, more extreme, obviously, but they're going through the shock and awe and confusion and all this other stuff, you know, as we are. They're kept in the dark too. So I want to talk about Celeste's clothing. That was mentioned. Her clothing was revealed. Everything from Victoria's Secret thong, leggings, and a Forever 21 tube top. So criminalist Lisa Alejandro also presented images of the clothing found with Celeste's remains displayed. This was displayed in court as her parents looked on. The garments included a Victoria's Secret thong, leggings, and a Forever 21 tube top. The clothing was described as a soaked, insect-covered, badly soiled mess by the time it reached the LAPD crime lab. So deteriorated that Alejandro testified some items couldn't be fully tested or preserved in typical fashion. The detail matters both because it humanizes Celeste in an unbearably intimate way. Ordinary teenage clothing brands, the kind any 14-year-old might wear, and because it plays into the broader defense argument about evidence degradation. If clothing this central to the case was too decomposed to yield full forensic value, the defense can point to that as one more example of evidence that couldn't be conclusively tied to a specific narrative. And it's crazy because you got a guy.
I don't know. I don't know if I was the defense that I would go that route. Can you imagine trying to tell a jury that, it can't be definitive because everything was, too horribly, contaminated to even keep as evidence. And then you're trying to, sell the same thing down because there's so much evidence against him. Imagine trying to, tell the jury that. If I was a jury member, I would be infuriated by that type of thing. And there is a real risk in this trial of jury alienation, I think, by pointing out things like that.
The persistence of it, right? Like every time you go to present something, there was not enough evidence. I mean, the persistence of it all will start making the jury, I think, in my mind, saying, you know what, will you stop with that?
Yeah, and imagine the what it's like to try and pretend that that if he was guilty, they should have been able to connect him to every single thing. That's not realistic. That's in no way is that the way reality presents itself. There's some things that they're going to make those connections on, and some things you're just not. So it's an unrealistic expectation, and it's motivated reasoning that the defense is becoming involved in to try and push and project that into the jury. And I think that a jury will react badly to that.
All right, Russ. So the question I got here is learning the specific ordinary brands of clothing Celeste was found in, items any teenager girl might buy, change how you personally connect with this case? And do you think prosecutors are using those details deliberately to humanize her in front of the judge? Why not? 14-year-old girl. Why not?
I think that's a little bit of wasted motion for the judge, though. Right now, I think that this is being put out there in the court of public opinion. And I think it's, not being done for the judge because they could have done a much shorter prelim on this. They could have taken less than a day if they wanted. This is for the court of public opinion. And most of all, I believe, like I said yesterday, this is softening David up. This is trying to force him into a position where he feels he has to take a plea. So he's not gonna, he may be reticent to, but at some point, if things keep going like this, and this is just the prelim, if things keep going like this for him, his defense attorneys are going to have to tell him, hey, look, we don't even believe you. You would be better off taking the plea. Although I will say at this point, it doesn't look like one is being offered. But, I get back to the California death penalty, of which I'm quite well acquainted. And it's defunct, but that doesn't mean that there's, something to be gained by sitting there and having a death sentence hanging over your head for, 15, 20, 25, 30 years. And so, he may want to dance with the devil he knows rather than the devil he doesn't.
Right. And let me do it. I got the transcript from one of the covers that Lauren Collin had. I want to see if there's anything else that adds, because she gets more information, which is it's spot on. So let me just let me see it all again, starting from we're on section 7. I think for me, though, I think we kind of touched on it yesterday. I get what you're saying, but I also feel they're trying to do what they can to make sure the special circumstances get, I guess, kind of get acknowledged and kind of get pushed through, because I think that's why they're waiting to announce if they're going to do the death penalty or not. I see some of the shows I was watching.
Well, they can't do the death penalty without getting those through the judge.
Right. So I think that's why I think so. From what I've been following, and I'm not an expert here, but I've been doing a lot of reading, a lot of watching these videos, watching some lawyers' channels on this case, and they're saying that right now this is being presented, and eventually the judge will kind of discuss what charges can be pushed through, and that would include the special circumstances. So I think that they are adding a little bit more than they may have done in other cases, because they're trying to push that motive. They're trying to push the murdering of a witness, the financial gain, and the lying in wait. And I think, to be honest with you, and I mentioned it in an earlier show today, they kind of build off each other, however you want to look at it. Lying in wait may be a little bit unique, but the financial gain and the murder of the witness, they kind of connect to each other. I did a show earlier today where I'm assuming they're going through all this stuff about David Burke knowing or not knowing how successful he was, but I'll guarantee you, when they found out Celeste's age and management brought Celeste back to her parents' house, management, Josh, whatever his name is, he probably had to sit down and told him what you have to lose with this girl hanging around here. And I think he may have tried to lie to Josh, trying to pretend that he didn't know that she was under 18, that she was an adult. I don't think he told him the truth. But I think at that point now we're aware. We don't want to have her come back, and these are the things you can lose. So I would love to see if they're going to bring him back and see if there was any dialogue that he had with David, just if they want to go that route, because they really want to push the financial gain. So I get what you're saying. They're kind of softening it, but I also think they're trying to push it to make sure that those special circumstances can be presented. Because I did read that part of this preliminary is deciding what charges can go forward, correct?
Well, it's part of it is what the ultimate penalty can be, and part of it is also the structure of the charges that are there. So they have to present probable cause for each and every one of those particular crimes as it's listed in the California Penal Code. So just as a for instance, whatever they had to do with the photos that he had on his phone or whatever, that's inclusive of part of this. And so the judge has to look at it and say, yes, this can be put before a jury, which must find beyond a reasonable doubt. But there is enough evidence here for them to be able to say, yes, this meets the threshold of probable cause, not only to make the arrest, but to send it to trial. And so that's what they're going to look at with regards to that. And so that's what, you know, everything is about. It's going to be about.
But can they make the decision also on the special circumstances that connect to the charge that can lead towards the death penalty? I mean, that gets decided.
Yeah, but it's a low threshold. It's the same thing as the crimes. It has to be whether or not there's probable cause with regards to those special circumstances.
Right.
And
so it makes sense for them to discuss the financials. It makes sense for them to discuss the text and where she.
It does. But what I'm saying is that these things routinely, now maybe not in a capital case so much, but routinely, sometimes all that they have is the hearsay evidence that's entered by the investigators and so forth. They didn't have to go this route, but they chose to, and I think that part of that is just the softening process. They could have done this. They could have done this in an afternoon.
You know what? So in the back and forths that I've been seeing, they actually don't think it would have been that quick. There are people saying that they expected this to be the quickest, would have been between 3 to 4 days, because they're presenting multiple angles to secure multiple charges with the special circumstances. So they were saying, just in the discussions I've been saying, that it was going to be a bit of a lengthy prelim trial, preliminary trial, because they're trying to push all these things out there to connect to the charges. I don't know going forward if all these things are going to be pushed through, because I haven't really seen much on the lying in wait. I think that's when you get the medical examiner. He'll talk about what he feels happened to her. And then, that's going to be hard, I think, that part.
I know. It's just to give you a little bit of history, though. So back in the day in California, they passed a law. It was actually a ballot measure, and it was Prop 115. And this was back right after I started in corrections. And so what this allowed for is instead of having this endless parade of witnesses for a prelim, they would just get what they call the QLE, Qualified Law Enforcement Officer, to come in and testify at the prelim. And so, lots of these just end up being, 30, 40, 50 minutes. And so in this case, because it could be a death penalty case, they might take a little longer, but it's usually only on those particular, parts of the special circumstances. And so this is getting drawn out. That's one thing that I don't like about this judge is I think he's kind of pandering to the media out there. And
it's
so
it's a she.
That's right. It's a she. I have a gray-haired old man pictured in my head. But they're just at the point where this is overkill now, in my opinion, because like I say, most of the time these things are wrapped up really quick.
I saw it the other way, but I get what you're saying. I see it the other way, that she is open to seeing that avenue for those special circumstances, knowing that these may be harder to prove. So I don't know if she's pandering to the media, even though you only see the same people going in all the time, but I don't think she's involved in the lottery process. But I think it's more of she's trying to see if they can get those special circumstances across, like the financial gain, the lying in wait. I don't know, but the financial gain and the killing of a witness, that's all. So I get what you're saying, but I think it may have required a bit of an exhausted effort, because if they didn't give it all you got 40 terabytes of evidence, 40 terabytes of evidence.
Yeah, so, but that's not about probable cause. That's about reasonable doubt.
Yeah, but you got probable cause in so many areas,
Yeah, it only has to tilt the scale to 51% though.
Yeah, but in so many different areas, it's not like it's one thing and we're going to go this perspective. No, they're trying to get them on so many different avenues. So I get what you're saying. If there was only one direct line from A to B that I need 51% of, then fine. What are we doing? But I think they're just kind of, and I think it's very strategic. I don't think they're just throwing things at a dartboard blindly. I think they're trying to hit things that matter. And I think what they're trying to do is show the strength of the case. But the one thing I think they're trying to do, and I do agree with you in softening, but I don't think it's a bad thing. I think they're trying to let Blair Burke know at this point, you're not going to want to go to trial with us.
Yeah, that's what I've been saying is they're softening him up, you know.
Right, no, I agree. So I don't think it's a bad thing. But
I don't think it's a bad thing, but I think it's unnecessary, and I think that you know, maybe they really do want that plea. I mean that on the prosecution side. But what I don't like is I don't like the way the judge at this point has, you know, in spite of what, you know, she did this morning, you know, with the live streaming and all that, has started to let it become this circus. And that was completely unnecessary. And then, you know, the prosecution, I understand that they got to do what they got to do. And they wanted this out there in the court of public opinion. And I think stupidly, I think the defense wanted it too. And now I think that the defense is not so happy about, you know, letting this thing take hold and take root like this, because now it feels inevitable. It feels
kicked out the blogger that was trying to stream things live.
Yeah, but she's let it get completely out of hand.
Well, what do you? I mean, anybody could get in when you do a lottery. You know, and what do you think's going in besides media, social media bloggers, outside of mainstream media? So now you got the body bag that couldn't be tested, which is like kind of like a defense opening. So one of the more, where am I? Just lost it. Freaking window closed. One of the more consequential evidentiary gaps discussed on day 3 involves the body bag Burke allegedly purchased ahead of time, in which Celeste's torso and head were found. According to reporting and commentary from the hearing, the bag had disintegrated to the point where it could not be meaningfully tested for DNA, and investigators removed only the handles and zipper before determining the rest was too damaged to preserve. That creates an obvious defense angle. If the handles and zippers were removed, the defense can ask why those pieces were not fully tested for DNA, especially if they were the parts most likely to have been handled during transport. The larger point is not that the body bag alone proves anything, but that it gives the defense a concrete example of evidence that was available in some form, but did not produce the kind of forensic certainty prosecutors would want. The body bag issue also fits into the broader theme of the hearing. Prosecutors have a lot of circumstantial material, but there are still pieces of the chain that can be attacked later. Even in a case this strong, the defense will keep pointing to degraded or untested items to argue sloppy collection, missed opportunities, or overconfident assumptions by investigators. So, Russ, the question is here: do you think the failure to fully test the body bags, handles, and zippers a meaningful evidentiary gap, or is it just one more technical issue that won't matter much once the rest of the evidence is lined up? We kind of touched on this with the chainsaws.
The substrates aren't in the handles and so forth, aren't the kind of thing that retains touch evidence DNA very well. They went ahead and they collected those parts of it, not the bags, but the handles, and I think some straps or something like that. And once again, we're back to the limitations on the swabs. We're back to the workflow of what it looks like for the collection process and what the lab's requirements are. So once again, much ado about nothing.
Yeah, I agree. All right, 2 more sections left for us. And as I'm doing this, I keep on losing subscribers. I mean, I'm working our asses off here. I don't know what the hell's going on. It's like I'm not getting served in the YouTube algorithm. I even, by the way, I've been following the Nolan Wells case, And now that it's going to go quiet until the grand jury, I think the mom is visiting with Cajun Navy to see the pictures of the body they had. Cajun Navy's fighting back about the words Crumps were using. The friends are now getting involved, talking about last sighting with Nolan and just how they feel about what's going on. I'm just going to stay quiet and then wait for it to be sent to the grand jury, because I think the case is going to unfold in the way we believe it will, and I'm just no longer going to put any effort into feeding into the chaos that it's become. Okay, so motive debate. Was this about money, fear, or both? So commentary around day 3 raised sharp questions about the prosecution's stated motive theory that Burke killed Celeste because she threatened to expose their relationship and ruin his career. Critics point out that prosecutors have not fully spelled out what exactly Celeste was threatening to do or demand, which leaves room for debate over whether the case is really about financial gain, fear of exposure, or a mix of both. One plausible reading is that this did not need to be a classic extortion scheme. A teenager in an illegal relationship could have threatened to tell people what was happening. And for Burke, that alone could have been catastrophic, because exposure could have meant prison and the end of his career. Under that theory, the prosecution's financial gain special circumstances does not require a literal blackmail demand, just that the killing was intended to protect the income and status he stood to lose, which could have been a better argument maybe, and then you still have the killing of a witness. There is also still uncertainty around how much Celeste's parents knew. She had been reported missing multiple times. Her phone was taken away at one point, and yet she reportedly still traveled internationally with Burke, including to London. And we kind of talked about how easy that process is, so I'm not really jumping on the bandwagon that the parents knew on that. That remains one of the parts of the story that does not fully line up publicly, especially for someone so young. And Russ, I covered that already on unaccompanied minors, and it was because the parents were being attacked because they automatically assumed, well, they must have known when she took a trip to London, as if it's the parents or guardian that automatically signed that off. And from what I saw, it's whoever fills out the paperwork, and then they have to go to the airport and then be the one physically dropping her off after they do the ID.
I think that what happened there was, in order to get through all of that, I think somebody posed as her guardian or her parent, and who knows, they might have only.
I don't know if they posed as the parent, but I think whoever. When David filled out the paperwork, and I think they may have used the name Victoria Mendez, whatever it is, whoever fills out that paperwork becomes responsible for that unaccompanied minor in the drop-off. So all they had to do is falsify the documentation, because she would have been ID'd. They would have wanted her passport. She would have been ID'd 100%. But the person dropping her off, I don't know if the airport's doing background on that. If that was the name on the paperwork that was sent, and this person can produce an ID saying, hey, I'm Victoria Mendez, I'm here, this is the paperwork I sent you guys, can you guys now take her to London? And then whoever picked her up on the other side could be anybody. Could have been another made-up name, could have been the family. And we know that this wasn't done by the money from Interscope. It was done.
You know what? I just want to point to one thing here is the CHP officer recovered that passport card, and there's something that we don't know on that is what it might have listed. It would have had to list who her parents or legal guardian was. And so, they're putting that into evidence right now. There's the London problem with how she got there. And so a passport card is not valid for international air travel. So when we see that going on, I think, I'm just wondering about exactly what information is on that card.
Well, they showed it. So Russ, wait a second before you.
Did they show it?
They showed it already in court when they were doing when the California Highway Patrol. It was a picture of it shown as evidence. They were something with redaction because I had her personal information on it. But if it didn't have if it was fabricated or had a fake, we would have known about that already. I think the passport was
No,
legit.
I'm not thinking about that. I'm thinking about if they used that to bootstrap it to some type of paperwork that she would have needed to go to London on. You can't use that for that specifically, but if you produced it as identification to show who your legal guardian was, if it wasn't up to snuff and they were doing something hinky, then that might lead back to whoever, lack of a better term, forged those documents or put some false information in there potentially.
Right. So my research on this was unique because I feel like I would love to maybe go to the airport. I live right by an airport and ask them how this works, because I think what happens here is you fill out the paperwork. They may not like, okay, so I may just put down I'm a guardian. I don't know how much background check the airport's going to do on that. All they're going to look at, I think, from what I'm reading, because when I first saw about this receipt, her name on it and all this stuff, and now she is showing her actual age. She's an unaccompanied minor. So now we know there probably is some truth in that passport. It's factual. Obviously, this would also rule that he did know her age if they could prove that he was involved in this. They put together the paperwork, and I believe what they do is they look at the paperwork that was submitted, and what they do is they just kind of look at the names that were on that paperwork. And then basically, so let's say, my kids, all of a sudden, my wife's mother decides that she's going to plan a trip for my daughters, unaccompanied minor, and she does the paperwork. I don't know if anybody's going back into that saying, well, she's not the parents, this can't be approved. When I first saw this posted on different social medias, whoever dropped it, I'll get the name soon. Lightning, I forget. Something with Lamp it was, I think, LAMP. I said, whoa, that's going to be a concern. And for a brief moment, I thought, well, maybe the parent now may have a concern. But then when I looked it up and did some research, Googled some stuff, also watched a video on unaccompanied minor process, it's not as secured as I would like it to be. But again, I would wish I could have someone from the airlines come on that I could interview. But from what I look at, I think that system has to be revamped. But I'm looking at it from the outside in. I don't know. I mean, Russ, we know this for a fact. You may look at something from the outside in, but the practice of something could be totally different.
Well, the airlines are wholly reliant on the government agencies for that. So, in order to get that passport card, they had to do this thing with what they call a DS-11 to get signatures with it, and that actually has to be presented to a passport agent to sign off on that. So there is undoubtedly a paper trail out there. We just don't know if the prosecution has run that down yet.
Well, Russ, she could have already had her passport. The family could have been involved in getting her passport for many other reasons. I mean, maybe she goes back and forth to Peru if she has family out there. I mean, I don't know, but it's not about so much getting the passport, but rather the trip to London.
Yeah, but that's what I'm getting at is that's the point at which the paper trail was definitely created at that point. And right now,
parents, so from what you're looking at, does the parents, let's do it this way. At any point during this unaccompanied minor, does the parents have to be involved in dropping her off or involved in the pickup? Or is that whoever, from what I read, it was basically the name attached to the paperwork that was filled out?
It's my understanding that that they have to produce paperwork linking at least to the parent or the guardian. Now beyond that, I don't know.
Now, is the guardian a legal guardian instead of
the
parents?
It has to be a legal guardian.
So I'm right. So that means that
it has to be someone that has a limited power of attorney.
I'm telling you, man. I mean, that may, but if that's the case, but Russ, that's not what Russ, if you look up right now, the process for an unaccompanied minor, and you put in, do the parents have to be involved in parents or legal guardian have to be involved in an unaccompanied minor on international travel. I don't know if that's the case. It keeps on going back to whoever fills out that original paperwork. So I'm thinking this: if he put Victoria Mendez on it, then he had to create some IDs for Victoria Mendez, and all Victoria Mendez had to do was just show up with Celeste. Celeste's passport and stuff, they're going to do their due diligence on, but I don't know if the person dropping them off goes through that much scrutiny.
Why do we think that she was unaccompanied?
No, they have that. It's on the ticket, I think.
Oh, is it? Okay.
It's one of the, it says it on the ticket that she was an unaccompanied minor. I think that's because he could, well, first off, it looks like he paid for this trip on his own, so it wasn't involved with anything with Interscope Records. So again, kind of operating under dark, which makes sense to my theory that after February 17th of 2024, because he was exposed, he started going undercover. But this part here is troublesome, because when I was on the cruise, I was on Bermuda, all of a sudden there were two videos that were popping up. One was with Asia Collins and her debate about knowing Celeste was young, him showing the ID, her not wanting to harass him, and then the receipt. And I was like, wait a second. I may have even done something right before that, I forget, but somewhere around a week or so, I just spent about a day. I mean, literally on may have been right before the cruise, but I think I could have sworn I may have done the video maybe on the cruise. I forget, but if you look at my shorts, because I think I made it a short, but the process was not as secured as I would like it to be. Now you're a better researcher than I am. Now, did you in your efforts? Because I know you're probably looking at it right now. Does the family have to be involved with international travel for an unaccompanied minor, or does it relate to just who filled out that paperwork?
Yeah, it has to lead directly back to whoever the guardians are, whether it's legal
Where does it say that?
or the non-traveling, and that has to be contained in a notarized consent letter.
Yes,
from those individuals.
Mentioned. So that's mentioned. You're right. So now, can that be falsified?
If I was going to do this, I would take the shortcut route, and I would go with maybe a birth certificate with someone else's name on it that already had identification in order to prove legal guardianship. So I think it's a really tough question, but we know that the paper trail exists somewhere. We just don't know how far they've uncovered it.
So let me ask you a question then, because you just made a good point, because I forgot about the notary. I forgot. Notary was mentioned. So when it comes to notary, the notary would be something from the parents or the legal guardian saying it's okay for this adult to drop my child off at the airport and to be picked up by such and such, and we're asking for the assistance because she'd be an unaccompanied minor, right? So it's not like that the parents have to show up, but rather the person that's dropping the child off have to have something notarized that the parents or guardian are in the know. Is that what you're saying?
That's my understanding. But it may not be correct.
So if that's the case, hypothetically, because I don't think the process is as secured as we like to be. I mean, does the notary, it adds an extra layer, but do you think someone can circumvent that?
Oh yeah, I mean it's circumventable. They just have to have the right identifications, which can be the birth certificate, but there has to be something that lines up on the birth certificate with the notarized copy of the travel plans and that kind of thing. So let's say Celeste Rivas got a hold of some paperwork that she would need from her house for this trip, because I'm sure, remember, she went back and forth a couple of times, so maybe we don't know that in her efforts to go back and forth, because they said she ran away,
Then she went home, came back, went home, came back. Maybe she was going home for things to get so she could do trips like this. Hypothetically, we don't know, but it's good to plug that in there. Let's just say hypothetically. So she's going back and forth, not to stay, but, oh shit, I'm going to need this. I'm going to need this from I'm going to have to find it. I'm going to have to take this. Maybe one day the mother's looking and can't find the birth certificate. You don't know, but maybe that explains some of the back and forth. Who knows? So if Celeste Rivas, let's say, somehow gets her birth certificate or whatever paperwork you need for the notary, then they would just forge the notary, correct?
I mean, there's so many possibilities. But you know, I think that it's incumbent upon the prosecution, though, to pull on that thread.
Right. So the only thing is, but when just to kind of move forward, we can't say 100% because she made these trips, the parents were involved and approved it. That's the goal. And I do think I like that.
Yeah, I would think that would be a hard no from them. No, you're not going to London.
Yeah, I can't believe how that lawyer was willing to talk to Steve Fisher and then doesn't even talk. And I've been interacting, like, which is generalized message, but he's been talking bad about the family. And here we are, always been respectful. Civil lawyers. Okay, so body camera footage from a welfare check we talked about remains central to this motive discussion. Deputies told Burke directly that Celeste was 13 and showed him a yearbook photo to prove it, while Burke told him she had claimed to be 18. That would be the motive of going to prison, you know, avoiding prison time. That footage is important because it undercuts any claim that he did not know her real age. So, Russ, do you find the prosecution's financial gain theory convincing as presented right now, or does the
Oh yeah, it's 100%.
Wait, or does the hurt, fright, and expose explanation feel more realistic for what may have triggered the killing? I mean, let me ask you a question, Russ. The financial gain obviously takes a little bit effort more to prove, even though they're trying to say he was ignorant. Or you could just say you were scared to go to prison, so you killed the witness, and maybe you don't get the financial gain, but you still killed the witness because she could have turned you in. But they wanted that financial gain. But it could have been an easier way just to say, well, you know, you're going to go to prison for what you're doing, and basically you killed the witness, and that's the special circumstance. I wonder why add that extra thing.
Well, the fear of being revealed, you know, it doesn't have to be an A or B choice. It can be both.
So I like what you're saying. So ultimately, I get it. So why not push for the financial gain? Because either way, it's going to automatically land on just the fact that you didn't want to be revealed.
Yeah.
All right, two last sections, guys, 9 and 10. Always let the cover here. So there's also a separate digital evidence thread involving Burke's cell phone and iCloud account. Prosecutors said a device belonging to David Anthony Burke contained a significant amount of child sex abuse material, and later reporting described the substantial quantity of child sexual abuse images stored on his iCloud account. That detail matters because it's not the same thing as the Tesla linked used for location mapping. In other words, there are at least 3 different digital buckets in this case. Burke's personal phone for cell site movement, the Tesla link device for line for vehicle movement, and the phone iCloud material tied to the child sex abuse material allegation. Public reporting has not said whether the child sex abuse material involves Celeste or someone else, so the safest wording is simply that prosecutors said the material was found on Burke's phone and iCloud account. But I think they narrowed it down that it's to her, so I don't think that's 100% accurate. This is worth adding because it answers a question listeners are almost certain to have when people say the phone, or are they talking about the location tracking phone or the phone tied to child sexual abuse material? Like Russ said, that allegation, Russ had asked that question. The answer appears to be no. Those are being treated as separate evidentiary issues. So Russ, does the separate child sex abuse material thread add useful context to the episode? Well, I guess to this episode, or does it risk muddying the narrative unless you clearly distinguish it from the location evidence? I mean, does it really matter? I think that question is just a little off.
Well, I'll just say this. When you look at what's on the phone, and I don't know, I can't pretend to know what the defense is thinking, but if it wasn't for the stuff on the phone, would they be thinking about, and I don't think that they would be, but what if he wanted to take the stand? And he was going to say, no, everything that happened was strictly platonic. But then you want to look at what's probative. And you know what's really probative with regards to that is that CSA material on his phone. And so he's not going to want to answer those questions. Now, I doubt that that really comes into play, but he might be willing to risk a lot, and he might be telling his lawyers, hey, I want to take the stand. So imagine this, imagine that, you know, he gets up there and, you know, he thinks he's a great actor or whatever. And so he says, no, it was purely platonic and she was just hanging around and I took pity on her. And so then the jury gets to hear that, and then the defense gets to cross-examine that and say, okay, let's discuss these photos on your phone. So I think that keeps him from certainly from any thought of taking the stand whatsoever, for whatever that's worth.
Yeah, I don't think it'd be a smart move to put him on the stand anyway.
I agree, but you can see, when you have something like that CSA material that's of probative value with regards to the relationship that he had with Celeste, then definitely not. But if he thought, oh, you know what, I can just bullshit my way through this, his attorneys are going to tell him, hey, you know what, the instant you say that, they have something of probative value to prove what kind of a person you really are. And that would end that.
Yeah, by the way, it ended with Dr. Grant Ho, H-O-E, it looks like, from Lauren Collins. She said that he only had about 5 minutes or the doctor only had about 5 minutes on the stand before the court adjourned, but he did give one especially stark detail, as we mentioned earlier. Celeste was 71 pounds, 5'2". She had braces. That testimony paired with the day's focus on DNA made the hearing feel especially clinical and devastating. So tomorrow we'll know more from the medical examiner, and then we'll see what comes next. Last section I have here, Russ, just for us to finish off, is what's next and how much longer will this go on, what's happening after. So as the latest reporting, the hearing seemed to be moving towards a close, even though it had originally been expected to run 3 to 5 days. LA County DA Nathan Hochman had said earlier that more than 10 witnesses could be called, including investigators, medical examiners, and witnesses tied to Burke's life and career. The practical point is that this is still a preliminary hearing, not the trial. Like Russ said, prosecutors only need to show probable cause, which is a much lower standard than proving guilt beyond reasonable doubt. And the amount of physical, digital, and testimonial evidence presented so far appears more than enough to send the case forward. That's what Russ said. What remains unresolved is whether the DA's office will seek the death penalty. Hochman has not yet announced that decision, and some of the evidentiary gaps, like the degraded body bag and the untested items, may matter more for charging strategy than to whether the case survives the preliminary hearing itself. So, I mean, how many witnesses they've done so far already? You know, so they got to be close to 10. And Russ, question here is, given everything laid out across the hearing, the forensic evidence, the cell data, the motive theory, and the digital allegation, do you think prosecutors are likely to pursue capital punishment, or does life without parole seem more likely? And by the way, I mean, before we answer that, because we're done, my notes are done. After the medical examiner, where else would you expect them to go? You think they could start closing it off at that point, or is there another area that you think, with the pattern we've seen so far, that you think that they would want to explore?
I don't. Tell me exactly what you mean by that.
Well, I'm thinking right now, the medical examiner could be the last witness they have on, and at that point, we're done. We presented our probable causes, preliminary trials over. Let's wait for the judge. Or do you think there's some angles that they may still want to push, or is the medical examiner the last stop?
I wish I knew in this. It just keeps going on and on and on.
Do you see any angle that they could add to at all?
Well, yeah. I mean, potentially. You know, what's in those pictures? So they haven't presented that part of the case yet. Have they? Did they do anything on that today?
They were just trying. No, they were just trying to. I think they're still. I think I could be wrong. I'm not an expert, but I think before they start trying to show what's on that phone. They want to try to create the ownership.
Well, yeah, but they can, but that's easy to do. And part of it is because it was in his cloud device. But the reason I bring that up is because that part does have to have probable cause behind it. But I think that they may try and gloss over that some if there's pictures of Celeste in that. So
they haven't shown it.
Yeah, and the reason that they would do that, is I think that they would want to hold some of their fire back, but maybe not. I don't know. I think the district attorney is getting a little bit out of pocket here, and not that I don't agree with giving it all, but I don't think that this is required at this point.
Yeah, they're saying maybe at the end you're going to have the rest of the medical examiner's testimony, so you may wrap up tomorrow. Wrap up from any DNA analyst or summary of digital evidence. So maybe that could go into the child sexual abuse, and then possible continued arguments over whether all discovery has been turned over and whether the case is ready to proceed. What are you thinking, Russ? Death penalty here eventually, or?
Man, the California death penalty is just really defunct. It's it's not very useful right now. To even try and get someone to plead because it's so far underwater at this point. But I think that there may be a chance that they're trying to at least use that to give him a reason. Endless waiting on death row, because even if you got the death penalty, you're right now with the governor that we have here in California. There's little chance that he would be executed in the next 30 years. So, for whatever that's worth.
Hey, Russ, I know that they don't have to release everything. I know you have the medical examiner. He's going to say 2 penetrating wounds. You don't think the prosecution will surprise everyone with? I mean, this guy David was so sloppy. You don't think the prosecution is going to surprise everyone with the weapon? I don't think they have.
So it seems a foregone conclusion that they didn't get the dismemberment tools. I would guess that the dismemberment tools and the weapon are in the same place wherever that is, and that I don't think that that's likely. It seems to me like he did some type of cleanup. They're probably somewhere between there and Santa Barbara would be my guess. So it's just looking at it, I doubt that they have the murder weapon.
So so this will obviously be they got to lean on everything circumstantial right now, or just the what's around it.
Yeah,
they still have to place. I mean, the 2 things I think is going to be having them in that location committing the crime with the weapon in hand, and it's going to be hard to say, well, okay, if you're so obvious he did it, what was the weapon? And they
I don't think that's going to play to a jury, saying that oh, where's the weapon, and well, it was obviously he's not gonna keep that. I mean, there's evidence of somebody. And most likely they'll be able to point to him that tried to cover it up. I don't think a jury likes to be patronized by that, but we'll see what the defense does.
Yeah, there was something I read before we go. It was from LA Mag. Remember, she's been in court all day, and she said after the lunch recess, the direct examination of LAPD William Roker continued as he further explained. She mentioned that. Where is it real quick? Wanted to ask you one more question. She talked about the Tesla, talked about perceived limitations by the defense, by the prosecution. This is this part. So Detective Roker finished his direct testimony by detailing that he received multiple sources to determine when Burke's Tesla was last driven. According to his analysis, surveillance footage, license plate reader data, and Tesla records, the vehicle was not moved or driven between 2 p.m. on July 29, 2025 and September 5th, 2025, which we talked about, when investigators ultimately recovered it. This corroborated previous law enforcement testimony about the last time a Tesla was driven. Now, during cross-examination, Marilyn Bednarski, one of his lawyers, David's lawyers, focused on what the defense perceived as limitations of Detective William Roker's cellular analysis. Bednarski established that Roker analysis in this case was based on call detail records and Tesla IMS records obtained from cellular carriers and not GPS data. Roker also confirmed he reviewed records associated with Celeste Rivas Hernandez's phone, but did not personally examine the device for any GPS information. He also testified that he did not conduct any drive testing in this case, explaining that his conclusions relied on timing, advanced data, and cell tower records rather than field testing. When pressed about the precision of his analysis, Roker agreed that the records could not point to an exact latitude or longitude, but maintained they provided accuracy of how far a device was from a particular cell tower. Bednarski pulled up one of the maps showing cellular activity near Burke's Donnie Drive residence. Roker agreed that based solely on the cell tower data, he could not note that Burke's phone was conclusively at the residence. He explained that the records show the device was consistent with being in the area of Donnie Drive. Bednarski also elicited testimony that the records technically could not identify who was inside the vehicle or who was definitively driving it on the dates discussed. Roker agreed he could not determine the driver's identity from the Tesla records, but said investigators received their conclusion that Burke was already driving by analyzing the vehicle's movements alongside the corresponding cell phone data belonging to him. Almost done, Russ. Hold on. Bednarski also pointed out a potential discrepancy. I just want to get your thoughts on this because I had this highlighted. Bednarski also pointed out the lawyer Bednarski also pointed out a potential discrepancy between the latitude and longitude coordinates displayed on one of Roker's exhibits, which marked where Celeste Rivas Hernandez's passport was recovered. He noted, however, these weren't his markings and the coordinates previously provided in court by California Highway Patrol Officer Sean Buenrostro. Roker testified that while the numbers were not identical, they were very close and reflected essentially the same location. All right, what's your thoughts on all that? That's very complicated for me. So what's your thoughts on this?
Much ado about nothing. That's what defense attorneys do is they point to discrepancies and then try and flesh them out into their what their whole case is predicated on. And since I didn't get to hear what that part of the testimony was like, and that someone is pointing explicitly to that, there may have been a redirect that came back with regard to that may have cleared some of that up. But the fact that it wasn't Bednarski's, actual notes or initials or whatever on that, it's much ado about nothing. They're not hanging their hat on a solid hook.
And then the last part here, Russ, I know you're going to go last part. This is the one last part before the medical examiner. The people's next witness was LAPD criminalist Samantha Tosh. We talked a little bit about this, who testified she has worked in the department about the DNA unit for 18 years, analyzing biological evidence such as blood, saliva, and semen. Tosh explained the crime lab's quality control procedure, telling the court that every step of the DNA testing process is documented, evidence is securely maintained, and analysts follow standardized protocols throughout an investigation. Tosh testified that she developed a full DNA profile from a toenail sample collected from Celeste Rivas Hernandez during the medical examination, as well as a reference DNA profile from a cheek swab provided by David Burke. She then compared those reference profiles to biological evidence recovered during the investigation. According to Tosh, multiple bloodstains collected from inside Burke's Tesla, including stains in the trunk and lower storage compartments, produced single-source female DNA profiles that include Celeste's DNA. She testified that the statistical analysis showed the DNA was 1 septillion times more likely to have originated from Celeste than from an unrelated individual. Tosh also testified about a blood stain recovered from a black rubber mat in the garage although that sample yielded only a partial DNA profile because less genetic material was available. She said 15 genetic markers were consistent with Celeste's DNA, making it approximately 20 quadrillion times more likely to have originated from Celeste than from someone else. Tosh went through additional DNA testing conducting on evidence recovered from Burke's residence and garage. She testified that bloodstains found on a rowing machine, a charger, and a green tarp each produced DNA profiles consistent with Celeste Rivas Hernandez. That's probably the multiple attempts he tried to dismember her, in my opinion, which with the statistical analysis indicating the samples were approximately 1 septillion times more likely to have originated from Celeste than from unrelated individuals. Of note, DNA recovered from a black trash bag produced a mixed DNA profile from 4 contributors, including 2 males, one being Burke, but Celeste was excluded. She went on to testify that bloodstains found on hand wipes produced a single source female DNA profile consistent with Celeste's, excluding Burke as the contributor. And then finally, during cross-examination, Burke emphasized the limitations of the DNA evidence presented. She first established that Tosh was not the primary analyst who conducted the DNA. There's the due process. The DNA testing in the case, but
that's hearsay testimony that's allowed in a prelim.
Right. Oh, yeah. Good point, Russ. And then, but was technical reviewer for work by another analyst, but indicated she contributed to the report. Tosh also acknowledged that prosecutor Beth Silverman reviewed with her the subject she would be asked about before her testimony so she could familiarize herself with the reports. Burke then turned to the science itself, eliciting testimony that while DNA testing can identify whether a person's genetic material is present, it cannot determine how the DNA was deposited, when it was left behind, or what activity caused it to be transferred. Or transferred. Tosh agreed DNA can remain on an item for weeks, months, or even years, and that lab testing cannot distinguish between DNA deposited through direct contact and DNA that could be transferred by other means. Burke continued to focus on the fact that DNA testing cannot explain how genetic material came to be on an object. Tosh agreed she could not determine how or when Celeste Rivas Hernandez's DNA was deposited on the rowing machine, and testified the same applied to the tarp, garage mat, and charger. Burke also questioned whether the DNA necessarily originated from blood. Tosh responded that she could not make that determination based on the DNA testing alone, and also acknowledged it was possible the DNA instead came from skin cells. And after the afternoon break, Burke turned back to the trash bags recovered during the investigation, referring to a second black trash bag containing wipes with brown stains. Burke established that the interior of the bag was not swabbed. We talked about that for DNA. Tosh also confirmed that no DNA from David Burke was identified on the trash bag and reiterated that the DNA recovered from the wipes was consistent with Celeste Rivas Hernandez, while Burke was excluded as the contributor. And then Burke revisited the separate trash bag containing a mixed DNA profile, questioning Tosh about the lab's conclusion that the sample was consistent with 4 contributors, at least 2 males. Tosh repeatedly testified the mixture was consistent with 4 contributors. Burke then questioned the use of the STR mix software. Nothing the software generated statistical estimates for each contributor and ultimately excluded Celeste from the mixture. When Burke asked whether David Burke's inclusion meant he was only a possible contributor, not a definitive one, Tosh ultimately agreed that characterization was fair. The attorney also brought up the number of people possibly going in and out of Burke's garage, and Tosh also stated that characterization was fair as well. And the last paragraph here is, during the redirect, Silverman clarified the distinction between what is possible and what is reported by the DNA analysis, citing that a sample would not be reported as matching the victim unless it was consistent with her DNA profile, and Tosh agreed, testifying that was correct. So, and then the other part we have here is it ended. The last witness of the day was Dr. Grant Ho, the deputy medical examiner with the Los Angeles County Medical Examiner's Office. He testified he has worked in the office for 5 years, has performed 2,500 autopsy examinations, and has testified in court roughly 40 times. Told the court he conducted the autopsy on the remains, identified through dental records as 14-year-old Celeste Rivas Hernandez. He testified at the time of her death she measured 5 feet 2 and 71 pounds. He described the remains as markedly decomposed, explaining that the condition significantly interfered with the autopsy examination. That's going to be unique that he said that, but it's the truth. And he also observed evidence of trauma to the body consistent with dismemberment of the extremities, and noted that Celeste was wearing braces at the time her remains were examined. Russ, a lot there with the that just came out from Blair Burke. Blair Burke. That just came out from Lauren Collin. She's been really providing some good details. I think we covered a lot of it, but what's your thoughts on the 4 contributors?
So again, that's just evidence of presence. And once again, if we go back and we look at everything that she discussed in that, would you say her name was Collins?
Lauren Collins. Yeah, she's good.
Lauren Collins. So in her testimony there, she already said that that those particular samples.
Lauren Collins wrote the article. She's a reporter on scene.
Yeah, that's what I'm saying.
Oh, you said testimony.
Well, the testimony that she's reporting on.
All right.
So the testimony that she's reporting on from the criminalist, clearly states that, hey, yeah, we don't know what the timeline is on these contributors. So it's evidence of presence, but it's not evidence of presence, during the dismemberment or the homicide. So all of that is consistent. Anyone could have left skin cells or saliva or anything else at that garage. So that has no more meaning than the fact that I think they said one of the samples of something not involving blood was that of Burke. You would expect them to find samples there, even if he was never there during the homicide or dismemberment, because he's living there. And so this is just part and parcel. I don't think that you can read anything specific into it, other than that it certainly seems that that's where probably the homicide happened, and definitely the dismemberment.
Yeah, they said earlier in the day they had found fake blood. They tested it was fake blood. We already talked about. She just released the article, so I'm just going through it. We already talked about the testing that this is earlier during the preliminary the day when they were talking to Wallace about the stuff that they didn't test. We talked about the burn cage. Wallace documented a large box containing a burn cage, to which Wallace responded she did not. I didn't test that. She was never instructed to search the second floor where the box burn cage was located. This was earlier today, right? So I'll make sure. Yeah, it was earlier today. Hold on, see if I missed anything. She just released this. On redirect prosecutor, I'm just going to skim through it. Beth Silman stated that investigators do not collect you mentioned that already, Russ. You covered that in very good detail about you don't need everything. So next witness for the people was LAPD criminalist Lisa Alejandro. We talked about her, a 26-year veteran of the department who specialized in trace evidence. They talked about the pool. Alejandro testified that several blue plastic fragments submitted by Los Angeles County Medical Examiner's office physically fit the missing section of the pool like a puzzle piece. But she also said several additional blue fragments shared the same characteristics of the pool material and could not be tested. Not tested. It didn't draw a definitive match. Let's see. Fits like a puzzle and could have originated from it, but she could not definitively conclude they were physical matches. Alejandro then testified about her examination of Celeste's clothing with brutal photographs displayed at the garments. The clothing we talked about, it was in poor condition with strong odor and significant deterioration and heavy soiling. The clothing, which included a pair of Skechers, socks, a Victoria's Secret thong, a heavily soiled Forever 21 tube top that may have originally been yellow, and black leggings that appeared to have been cut off in half. That's probably, remember, they cut her by the knees. Alejandro explained that the heavy soiling prevented her from performing some of the comparison testing she had been asked to conduct. And then while examining the leg top, she recovered dark blue and medium blue plastic fragments that were visually similar to those submitted by the Los Angeles County Medical Examiner's Office. Exhibits also showed a separate black fragment that Alejandro compared to the leggings. She testified that she collected hairs, fibers, other trace particles, and 2 yellowish stains from the black fragment using sterile swabs, but could not complete the analysis because of the deteriorated condition of the clothing. And then during cross-examination, let's speed through this. Defense Attorney Blair Burke questioned the scope of Alejandro's analysis, pointing out, you mentioned that already, that fragment comparisons were based on physical characteristics and were not exhaustive. Burke also asked about the hairs, plant debris, and other trace material recovered from the inflatable pool, with Alejandro explaining that some debris naturally fell onto the examination paper during the inspection, while other material was manually collected. Burke pushed on her previous testimony regarding possible footwear impressions observed on the pool. The criminalist testified that her attempt to lift the impression using an electrostatic dust print lifter was unsuccessful, explaining that the pool's uneven, thick surface or the possibility that the impression were not made in dust could have all prevented the recovery. She's very detailed. And then Alejandro also confirmed that investigators never provided her with any shoe for comparison to the possible impression. That's if you stood in the pool while doing it. And Silverman's next witness was William Roker. We kind of, let me see if there's anything else. He's been working with the FBI for cellular data. We talked about that, worked for Verizon Wireless. Law Enforcement Division testified that he was asked by lead detective Joshua Byers to analyze 2 identifiers, one associated with David Anthony Burke's cell phone, another tied to Burke's Tesla, MSI, or International Mobile Subscriber Identity. And it wraps up here. So he used the data. According to his analysis, Burke's phone and the Tesla appeared to travel together from the Doney Drive residence towards a remote area of the State Route 154 in Santa Barbara County. We talked about that. Was routed. Then he made the phone call. We talked about that. He also identified additional trips. We talked about that. The court was also shown maps of the cell tower data, a Tesla charging station in Santa Ynez that matched the vehicle's infotainment records. And then Roker testified that the cell phone records consistently corroborated the Tesla data showing the 2 devices traveling in unison. Wow, she is very detailed, Russ. Anything you want to say in closing, Russ, or anything related to what I just read? I just popped out. The article just popped up. You're muted, Russ.
My dogs were running around. So anyway, I just think, we covered, everything that was in there today. And once again, I hope they wrap this up and start getting ready to move it forward.
Well, let's see what you said. See if this happens tomorrow.
I don't think it's going to. I think that the DA is invested in the process for a number of reasons, included, like I said, softening up David. But I think now that people are playing too much to the tune of what the media has going on with this, because it's getting people clicks.
Well, the defense would benefit, right? The longer it goes.
No, I don't think so. I think that because part of the reason to do this, not just the media circus and not just softening David up, is to try it in the court of public opinion and get people just, saying and thinking that he's guilty. And they're not landing anything. They've reduced themselves to trying to create discrepancy, for discrepancy's sake. It's not discrepancy that actually leads anywhere that I've seen. It's just discrepancy for discrepancy's sake.
Yeah, they I thought maybe if it goes longer, they have more opportunities to present arguments, especially
no, because all that they can really do is because you got to understand that right now not all of the discovery has happened. They might get tipped off to some of the discovery, but the way it's going right now, I bet I would be willing to say that I think that the defense right now is going, please let this end. Please let this end.
Hey, Russ, I just sent you the ticket, the plane ticket.
Yeah, there's potentially some more I found on that, because supposedly there's some kind of indicator that she was not an unaccompanied minor, and that begs the question why that's on the ticket.
Well, so as I previously, so he said during D4vd's preliminary hearing, prosecutor said he used his personal bank account to purchase multiple airline tickets for Celeste Rivas Hernandez. According to evidence presented in court, one of those bookings was for a flight from Los Angeles to London on September 28th to the 29th, 2024. So she's flying overnight, where Celeste was listed as an unaccompanied minor between the ages of 12 and 14.
On the ticket.
Right. Prosecutors also said he purchased additional plane tickets for the two of them to travel to Texas. D4vd has claimed he did not know Celeste was a minor. This is just another piece of evidence that proves he did, and he was doing his very best to make sure that nobody else knew. But so, Russ, I just said, hey guys, this is the ticket. I don't know. Let me just show you guys so you can see I have it. It's coming from Matt Thibodeau. That's the ticket. I mean, maybe I could just email myself this. But Russ, you got the ticket?
Well, yeah, but I just think that there may be some indicators that and I haven't had a chance to look into all of them yet, that she may not have been an unaccompanied minor. There may have been someone with her. But
no. I know what you're saying on the sly.
I'm saying that, yeah. Well, what I'm saying is on some of the other paperwork right now that I'm looking at, it did not necessarily list her as that. So why did it say that on the ticket?
So do we have? I wonder if we have a date of when.
I have to look into it further because there's nothing definitive yet, but it's just something that I was looking into.
Well, that's interesting, Russ. I wonder if she went to. So you're saying if she went to, maybe he was on one. Maybe he was. Can I ask you a question, Russ?
Yeah.
I think, in my opinion, and guys, people that are following this case, feel free to chime in if you know more than I do. His flight would have been paid for by Interscope, let's say. So he would have probably been on a different flight, and then he could have flown her on on her own and been picked up, so he couldn't have been connected to her.
Maybe.
You think that makes sense?
Oh, I don't know, because it said though that he's the one that purchased the tickets. So
yeah. Well, it's not under his name, but it did come from his personal account. Yeah. Also, maybe it is. Yeah, the money came from his. So, however, they tracked that, but then the name that I think was connected to the unaccompanied minor was the alias Victoria Mendez, if that's a fake name. But look, it says if your child is traveling without an adult, call us to set up your child's trip through our unaccompanied minor service. Before their trip, you need to pay a service fee for unaccompanied minors. You must also provide information about who will drop off and pick up your child and their emergency contact. If your child is traveling with an adult who has a separate reservation, your child can travel with an adult who has a separate reservation. Just give a call. So it just said it relates to the paperwork, Russ.
I know, but there's supposedly two accounts. There was buyer's testimony, and I can't even think of what the other one. It was
Gonzalez, the Spanish.
It was something about the itineraries and whether or not one leg was one thing and the other. But I got to get back to it because I don't have it all right here before me.
Maybe we could revisit it tomorrow when we get the updates for this case.
Yeah, it had something to do with a booking change, and so not really sure. I have to look through it better.
All right, Russ, you have anything you want to wrap up with?
I'm good. I've said all I can say tonight.
Yeah. Okay. And guys, my closing thought is, well, Russ, you can head out, Russ. I just want to just get a safe thought here on the flight.
All right. Ciao, people.
All right. Take care, Russ. Bye. Let me just get myself back on because I got to figure something out real quick, guys. Hold on a second. It doesn't seem that they're on the same flight, but reporting and commentary suggests Celeste was put on a flight to London as an unaccompanied minor and that Burke was separately associated with London and Texas travel. The strongest public claim is that prosecutors say Burke bought a ticket to Celeste for a flight from Los Angeles to London and that she was listed as 12 to 14 years old as an unaccompanied minor. The flight receipt commentary also suggests she may have flown by herself with Burke already in London or otherwise tied to the trip. But that's coming from a secondary commentary. And the border timeline report says Celeste and Burke allegedly spent time together in Texas as well, so the family would be involved. Guys, this case is, the more you find out, the more questions you got. But again, another deep dive. Great job with Lauren Collins with the stuff she's reporting, so I'm definitely going to wait for her stuff to come out. I read her stuff all the time. I try to add it into what I'm doing, but there's a lot there. Hopefully we covered a lot. All right, guys, if you like the content, buy me a cup of coffee. Link to that subscription as well as top of the YouTube channel. Stay safe.